What is the DA's office afraid of? It's just my asking the court to order the DA's office to make sure that this evidence is preserved.
My concern, and it's certainly not that I'm afraid, my concern is that it almost seems as positive as the defense is essentially trying to direct Commonwealth's investigation. I don't find that any of this information is particularly relevant. It's not something that I was pursuing this kind of case.
Karen Reed led into court in handcuffs.
And how do you wish to plead to those indictments?
Nothing.
In the same area where the body had been recovered, 2 red plastic pieces of a taillight were located, consistent to the pieces missing from the defendant's black Lexus. She opined from her examination that the significant blunt force trauma injuries occurred prior to Mr. O'Keefe's becoming hypothermic.
We have photographic evidence that my client's vehicle, before it was taken by the police, was in different condition than when the police actually evaluated it. There's no flight here, there's fight. We are fighting this case because she is innocent.
The victim and the defendant have been arguing for quite some time, numerous times over the weeks preceding this, that on one occasion the victim had attempted to break up with the defendant.
He's got scratch marks all up and down his arm that are completely unexplained. He's got 2 black eyes, appears to have a broken nose. There's something else going on here.
The lead detective is very close with the owners of that property. And he was supposedly assigned to the case to avoid the appearance of impropriety.
Charges against Reed have been upgraded from manslaughter to second-degree murder. She's been released on $100,000 cash bail, and she'll be back in court in August.
Jimmy Friday. Jimmy's not here.
Yeah, Jimmy Friday.
But Jimmy's not here. So what's that?
We're coming in all right, please. I think you'll be okay. Court summons session. First call, the criminal list. Judge, I'd like to start with number 8 on the list, Karen Reed, Mr. Yannetti, and Mr. Lally. Can I have counsel for the Commonwealth identify themselves, please, for the record?
Adam Lally for the Commonwealth. Good afternoon, Your Honor.
Okay, good afternoon.
For the
Good afternoon,
defendant.
Your Honor. David Yannetti for Karen Reed. May my client join me at counsel table? Your
Yes. All right. Pretrial conference. What's the current status of discovery?
Your Honor, the discovery is still ongoing. There's several matters, several items forensically that are at the lab, and there's several other items that are subject to forensic electronic examination, which have yet to be entered into. They're going through a decryption process. Spoken to counsel at length about that and a couple other discovery items. I think collectively we're looking for a little more time to go through everything to make so I can ensure that he has everything that I have up until this point. He did file some counsel, and I'll let Mr. Yannetti obviously speak for himself, but there were some discovery motions that I received today that were filed, I believe, today as well, dealing with a number of issues, most of which I think Mr. Yannetti already has. Certainly anything that he doesn't have, I'll provide as quickly as I can. But we spoke about a further pretrial conference date of September 22nd at 2 p.m. if that's amenable to the court.
Can we do the 22nd, Jim?
We can, for
Okay.
further pretrial conference.
Further
Yes, please.
pretrial conference. So just with respect to these motions that were filed today, there's defendant's motion to compel production of materials listed in the notice of discovery 1. I'm sure those were intended to be produced. If they weren't produced, I'm sure you're going to produce them, right?
Correct, Your Honor.
Okay, so I think I'll take no action on that in light of the Commonwealth's response. Does that make sense, Mr. Yannetti?
You know, Your Honor, it does, because I've received further material from the Commonwealth today, and I think what I should do is go through that and cross-reference it against what has previously been provided. So I'm happy to just file that motion today and hold off on having a ruling on it, perhaps till the next date.
Well, I've endorsed it as no action taken in light of the Commonwealth's response. So if we end up having to bring something up with regard to that, we'll deal with it down the road.
Thank you, Your Honor.
There's a motion to inspect the taillight and housing. Any problem with that?
No, Your Honor, the only issue with that is those items are, there's another motion to inspect. All those items are currently at the lab, so as soon as they're back from the lab, then I'll certainly contact counsel, and we can arrange a time for his expert and himself to view and inspect.
Is that satisfactory, Mr. Yannetti?
Yes, it is, Your Honor.
So the motion with regard to the taillight is allowed after the items are back from the lab, and the same will be true with respect to Mr. O'Keefe's clothing. The final motion is an emergency motion to compel production of requests for preservation of Google geofence data. And that seems like it's time sensitive. Have you resolved that one?
Yes, Your Honor, there's no objection to that.
No objection? Okay. Mr. Yannetti, do you expect to file any other discovery motions?
Yes, I do, Your Honor. That's part of the reason why we were jointly requesting a further pretrial conference.
That's fine. I just want to make sure we don't get the filings on the same day as the hearing as these were.
No, I had told Mr. Lally when we conferred today that I will get them to him in plenty of time to review and have the court review them as well.
Okay. So filing by September 15?
Yeah, I was going to suggest that.
All right. Filing by September 15. Anything else we can do today?
No, I just wanted to make sure it's a 2 p.m. call.
It is.
September 22. I think that's all we need for today, Judge.
Thank you.
9:22, 2 p.m., further pretrial conference. Any
Thank you, Your
motions to be filed by 9:15? Thank you.
Thank you, Your Honor. Thank you, Mr. Clerk.
Sure.
Your Honor, number 4 on the list is Commonwealth versus Karen Reed, indictment 22CR117. Can the attorneys please state their appearances?
Adam Lally for the Commonwealth. Good afternoon again, Your Honor.
Hey, Mr. Lally.
Good morning, or good afternoon, Your Honor. Attorney David Yannetti on behalf of Karen Reed. Behind me is Attorney Ian Henchy, who has filed an appearance. He's my associate. Also at counsel table are Attorney Alan Jackson and Attorney Elizabeth Little, regarding whom there is a motion to have them admitted pro hoc vice, which I'm hopeful that the court would allow.
I saw that. Any objection to the motion for pro hoc vice?
To whatever extent I have standing on it, Your Honor, no.
I don't think you necessarily do. Okay. That will be allowed. All right. A raft of motions were filed in the last couple days. Are the parties prepared to address any of them?
So, Your Honor, as a preliminary matter, these were filed by the September 15th deadline that the court had set. However, they are admittedly lengthy, with a lot of meat to them. I did confer with ADA Lally. He's asked for more time to respond to some of the motions. So we have agreed, subject to the court's approval, that we are strictly dealing with motions of preservation today. So if I could address, and my co-counsel could address those specific motions.
All right. So I have a motion to compel discovery. That we're not dealing with, right?
That would be on the next court date.
Motion for discovery regarding circumstances of a Mass State Trooper's assignment.
For the next date.
All right. Motion for preservation of samples for independent forensic testing.
I would like to be heard on that
Is
motion.
there any opposition?
No, Your Honor.
Okay. I don't think you need to be heard.
Great.
Allowed without opposition. Motions to renew motions previously filed in the Stoughton District Court prior to indictment. Were those motions acted on in the Stoughton District Court?
They were and allowed by Judge O'Malley.
All right.
In Stoughton.
Any reason that those shouldn't be adopted here?
Your Honor, some were, some were not. If we could reserve those for the next date, I really am only in a position to address a preservation today.
Okay. Motion for an order under Rule 17, that would be in the next date?
Actually, with regard to that motion, Your Honor, we're asking for preservation of those cell phones. And Attorney Little is prepared to address the court on that issue to the extent that there's an objection today. We expect that we would ask for production of the data on the next date.
I'm just looking at the motion. Is there something in the motion that asks for them to be preserved?
There, Your Honor, with permission, Alan Jackson on behalf of Ms. Reed.
Yes.
And by the way, thank you for granting us pro hoc vice status. It's a pleasure to be before the court. With regard to that motion specifically, there was not a preservation request. We didn't know what the time frame was going to be for the hearing, nor the actual presentation, if there is going to be presentation of the actual evidence, the phones and the data concomitant to the phones. All we're asking for right now is an oral order by the court to preserve the data until at least until the next court hearing, which we hope will be October 4th.
Where are the phones?
We believe they're in the possession of the individuals that are named in the motion, and Ms. Little can name those for the record. We're not asking for any affirmative action on behalf of or on the part of any of the individuals, simply that they do not destroy, delete, alter, or in any way manipulate the data on those phones until the court has an opportunity to hear the motion.
Mr. Lally?
Your Honor, I'm not really sure what authority the court has to do that, specifically without a preservation request being part of the motion. These are physical objects that are in the possession of third parties. So I question whether or not the court has really the authority to do that. But I certainly can reach out to each of the individual witnesses and advise them of the presence of the order. The question I have as well in regard to that is following along with the process pursuant to Rule 17. First, there's no Rule 17A2. So I'm not really sure what posture we're in as far as my requirements to provide notice to the third party record or object holders. So that was my initial sort of assessment is dealing with the next state as a 17A2 hearing, and then scheduling a Rule 17 further beyond that after providing notice to the parties, the third party holders of the particular objects. But I'm not sure really what counsel is asking the court to do in reference to physical objects that aren't in possession or custody and control of the Commonwealth and are personal cell phones that may or may not even exist at this point. I can't speak to it either way.
What do you say the authority is that I have under Rule 17A2 or any other authority to compel a third party who has not yet been ordered to produce any documents, and the court's made no finding of relevance, to order them to preserve information on in their database, if you will, the phone's brain?
I believe it's the court's inherent authority to order the prosecution to at least notify the third party individuals that the prosecution, the Commonwealth, is now on notice of, that it's at least the court's intent that data not be destroyed. It goes to the inherent fairness of the process. They know that we want data from the phones. They now are on notice that we want data from the phones. If that data is thereafter deleted, destroyed, altered, manipulated, or in any other way sort of gone from our grasp, if you will, I think that's at their peril. That's at the Commonwealth's peril. They're now on notice that we are seeking this data. We have no control to go get it, other than to ask the court to provide it to us via Rule 17. We've made that motion. We've done our due diligence. Between now and then, all of the individuals that we're in a public filing that we're seeking the data from are now on notice that we're seeking that data. I think if the court were to order the Commonwealth to simply notify the individuals, that's the intent of the court, that none of this data be altered or manipulated or deleted, that would satisfy us, as long as there's a compliance component with that and the Commonwealth is deemed to have provided us and the court some level of satisfaction that he's at least attempted to reach out to these third parties to say, don't delete, don't destroy, don't get rid of this evidence.
Have you given those witnesses notice?
Have we?
Yes.
We have not, of course.
Why not?
Well, because we just filed the motion. And there's no way for us to give them notice unless and until the court, I believe, under Rule 17.
They're third parties, right? You could send them a letter saying, we're seeking, we're filing a motion with the court to get this information. Please don't destroy it.
We could. Or in alternative to that, I think it would have more power and certainly more punch if the court were to order the Commonwealth to do that exact thing, and it comes on the Commonwealth's letterhead. I can certainly send a letter. I don't know that they wouldn't take that letter and round file the letter. I think something from the court would have a different impact.
Do you have a proposed form of order you want the court to consider?
I would ask the court to simply make an oral order to Mr. Lally that he is to notify each of the witnesses named in the Rule 17, to the best of his ability, that nothing is to be deleted, altered, destroyed, or in any way manipulated.
I don't like oral orders because they can be misconstrued and can't be enforced very easily. Mr. Lally, what is your view about notifying these folks? I think you just volunteered to do it a minute ago.
I certainly, again, so what my interpretation on this would be is, as far as where we are in the process, is I can certainly treat today as a 17A2, but again, I'm not prepared to address relevancy at this point, but sort of skipping ahead to a certain extent, I'd have no issue as far as forwarding a typical Rule 17 notification along with a copy of counsel's motion to each of the respective parties. But I do not feel comfortable ordering them to do or not do whatever with items that are in their personal possession, at least at this juncture.
All right, Mr. Jackson, if you want a preservation order, it's going to have to be in writing from me, okay? And you can draft it and send it into Mr. Roach by email. I'll consider it. Circulate it to Mr. Lally before you send it in to Mr. Roach. And you can do that, this afternoon or first thing in the morning.
Understood.
And I'll take a look at it and understand that this is simply putting these folks on notice. This would be a letter from the Commonwealth, essentially, attaching an order from the court, putting these folks on notice that this motion is pending and that there's going to be a hearing on it on a certain date. And that the court has, and that the cell phones and the data on it should be preserved until the court can act.
Happy to do that, Your Honor. Thank you.
All right. So that one I'll hold on to until I see this proposed form of order. If you send that order in Word form, it would be easiest for the court because then I can play with it if I feel like it's necessary.
Absolutely.
There's an amended motion to compel modification of a Google preservation requests.
Yes, Your Honor, if I can address that motion, it actually ties into our motion to renew motions previously filed and allowed in the Stoughton District Court, because we did get an order of, or the Commonwealth, I should say, was ordered to notify Google to preserve geofence data, and there were specifics regarding that order. The most important part were the location and the dates.
Okay, and does that expire?
It doesn't, but it hasn't been complied with, and that's part of. And not only that,
How do you know it hasn't been complied with?
Because the preservation requests that have been sent to me from the Commonwealth do not comply with the court's orders. So if I can just be heard briefly, Judge, the Stoughton.
Before you go,
yes,
is this a motion you're prepared to address today, Mr. Lally?
In the respect of the request, and I'm not sure there interplay between some of the motions that I saw, but as far as a motion to preserve any and all information received, I have no issue with that. But as far as the rest of it or the substantive portion of the motion, I'm not addressing that today.
And that was my understanding, Judge. The preservation aspect of this is all we are seeking to accomplish today. These were allowed back in May by the Stoughton District Court judge. We still do not have evidence that Google has been ordered to preserve what Judge O'Malley ordered the Commonwealth to request them to preserve. In the motion itself, there's a couple of paragraphs about the sort of the procedural history.
What I don't see attached to the motion is what you say the district court ordered.
That is actually attached to my motion to renew motions previously filed in Stoughton District Court.
Well, that's attached to another motion.
Correct.
So where is that?
The court had previously.
Yep, I've got that, but I'm.
As you can see, there are several motions, Judge.
This is the motion to renew motions previously filed in the Stoughton District Court, but I'm trying to find the right attachment.
Right.
Nothing is tabbed here, so I just have a pile of papers.
Right. So the attachment is defendant's motion for preservation of Google geofence data, which was filed on April 29th, allowed by the judge on May 6th. I believe it is the second motion after the docket sheet.
I see. It's a 5-page motion.
Correct.
It says allowed.
Correct.
All right. And where is the Commonwealth's notice to Google that you say is wanting?
So the Commonwealth had Trooper Michael Proctor send over the preservation request. The first one was sent on I believe, May 13th. And in that motion,
Do you have this as an attachment?
I don't believe it's attached to the motion. I outline it in the body of the motion, Judge.
What page?
Page 11. The section is entitled Chronology and Procedural History Relating to the Geofence Warrant.
And that's an attachment 28. The attachments that I have are not numbered. There's a footnote here, footnote 35, that references Exhibit 28. Is that the reservation order?
That's correct, Judge.
Do you have a copy of it that I can take a look at? Because
that is something that we delivered.
Hold on 1 second. I think I may have just inadvertently turned to that page. This is May 13 of 2022?
Correct.
From Trooper Michael Proctor.
Correct.
Yeah, that does not look like it addresses the geofence data that was ordered.
Right. And what it did, Your Honor, was narrow the requested geofence data for only apps that were downloaded from the Google Play Store, which would essentially eliminate 70 or 80% of the cell phones in existence, since iPhones and Apple carry such a large part of the market. So we contacted ADA Lally to inform him of this, and then another modified preservation request went out, which appeared to be satisfactory. But the problem is Google only sent an automated response saying that it had received the original flawed first preservation request, and then Google never sent anything to say we will actually preserve the data. We have never received even an automated request from Google that they would preserve the iPhone data in the corrected preservation requests. And then, we have other issues.
Do I have the corrected version in the package of material you submitted?
Yes, I believe that is Exhibit 41. I'm sorry, Exhibit 31. It's footnote 41.
Amendment to preservation by Michael. This is May 19?
Correct.
All right. So you're just trying to get confirmation that Google has received and will comply with the amended notice?
Correct.
Okay. Any problem with that, Mr. Lally?
I'm sorry, problem with what, Your Honor?
The notice has already gone to Google.
Correct.
Seeking to have them preserve the geofence data. Is there any way to get confirmation from Google that they've received it and are doing that?
You can certainly get, I would imagine, yes. We could
I would
certainly
think
get
so.
confirmation if it exists, yes.
Okay. All right.
There are two ways, Judge. The first way would be an automated response from Google saying, we received your request, we'll get to it. And then the second would be where the rubber meets the road, which is we will preserve the data. We don't have either with regard to the amended request.
I understand. So Mr. Lally has to make some inquiries or have his trooper make some inquiries about what the status is with Google of that preservation request. And hopefully you'll have that answer by whenever we have a hearing on all the motions.
Yes. And
I don't think it requires a further order from the court. You're just trying to get some information as to whether Google in fact got that preservation order.
right. Although if the court does not order Mr. Lally to do it now, then I didn't understand the court. Is the court ordering Mr. Lally to do it or not?
No, Mr. Lally's agreed to do it.
Okay.
And I don't think I need a court order. I'm asking him to do it. He's agreed to do it.
Okay.
It's going to take some time to get a response from Google, perhaps. So hopefully we'll have an answer by the next hearing.
I'm hoping. And Your Honor, just one issue regarding the previously allowed by agreement motion for preservation of samples for independent testing. The only thing I forgot to mention to the court is that the medical examiner's office had flagged that it would be destroying samples 9 months after receipt. And that date is coming up and likely will occur before our next court date. So time is of the essence. That's why we needed the hearing to go forward today. So my hope is that ADA Lally or somebody from his office today or tomorrow will contact the ME's office to say, do not destroy samples of anything taken from the...
I've ordered it. You can take a copy of my motion and you can send it to the crime lab. You can send it to the CME and Mr. O'Malley. Mr. Lally, excuse me, can do the same thing.
Thank you, Judge.
Okay?
Here, I'll go one step further. I will send an email to the lab and I'll CC Mr. Yannetti on the email.
Great. Next dates, you folks had an agreement to a date?
We do, subject to the court's approval. We had discussed 2 p.m. on October 4, Judge. All counsel are available.
Judge Canoni will be in the session that day, and that date, for some reason, is not available on her calendar. You can't do the 4th, 6th, 11th, or 12th. Most other days would work.
What about October 3rd? Would that be possible? At 2 p.m.?
Yes.
That's fine, Your Honor. Just as long as I can understand, as far as the Rule 17 is concerned, I just want to, are we at the 17A2 stage? We're going to be arguing.
We haven't had any hearing on the 17
okay.
motions, so
Understood.
this is a first hearing on a 17 motion. Okay?
I just want to make sure my obligations about notifying parties to be here are not.
Right.
Okay. Thank you.
Okay?
October 3 at 2 p.m. That'll be for motion hearing date.
Thank you very much, Your Honor.
Thank you.
All right, and I'll get a proposed form of an order from you, presumably by tomorrow.
Hopefully by the end of the day, if not
Okay?
tomorrow.
Very good.
Thank you, Your Honor.
Let's recall number 2, Commonwealth vs. Robert, 20CR143.
Number 12, Karen Reed.
This might take a while. This might take a while.
Okay. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good afternoon, Your Honor. Adam Lally for the Commonwealth.
Good afternoon, Mr. Lally.
Good afternoon, Your Honor. David Yannetti for Karen Reed. With me is Attorney Ian Henchy, Attorney Elizabeth Little, and Attorney Alan Jackson, all on behalf of Karen Reed.
Good afternoon, counsel.
Good afternoon, Your Honor.
Good afternoon, Ms. Reed. Ms. Reed, you can have a seat. All right, so there are a series of, who's arguing this afternoon?
Your Honor, on that issue, there are several motions. Mr. Jackson will be arguing the Rule 17 motion regarding the cell phones. I believe that is the one that is most contested. It may make sense to deal with that motion first, and then the other motions could flow from that.
Okay. Johnny, can I see you for a second?
Sure.
No, John. All right, I read the Rule 17 motion over the weekend, and I received the Commonwealth's response to it this morning. So, all right, I will hear from you, Mr. Jackson.
Thank you, Your Honor. I'm not going to repeat everything that's in our moving papers for obvious reasons.
Oh, I'm sorry. I am going to interrupt you, though. So I did notice when the motion was filed, there were grand jury minutes attached. I'm addressing this to you, Mr. Yannetti. There are grand jury minutes attached. Did you file a motion to impound?
I did not, Your Honor.
Okay, so you know the grand jury minutes have to be impounded, right? So you asking me to impound them now?
And that is fine, Judge, yes.
All right, so Mr. Clerk, we will impound
Yes, Your Honor.
the exhibits to that. All right, thank you. With that now, Mr. Jackson, I'll hear you.
And I appreciate that. I'm not going to go over every single thing in the defense moving papers. Obviously, the court has had an opportunity to read those. But I do want to highlight a couple of things, especially as it relates to the relevance, the admissibility, the necessity, and the specificity of the items that are being requested. And what we're asking the court to do basically is order key percipient witnesses and possible suspects to the events of January 29th to provide their cell phones and the data that's concomitant to those cell phones for a very limited period of time, the 7 days bracketing the incident on January 28th going into the early morning hours of the 29th. Basically, the request is for January 28th through February 4th, and that includes individuals specifically named in the motion: Brian Albert, Nicole Albert, Matthew McCabe, Julie Albert, Brian Higgins, Colin Albert, and Julie Nagel. Obviously, the second portion of our motion deals with Jennifer McCabe, but my understanding, and I spoke with counsel this morning, counsel for the Commonwealth, at least their understanding and now our understanding is that they have a fully imaged telephone. It's been forensically imaged. They've got it. We're going to provide a terabyte level hard drive and ask the Commonwealth to provide that mirror image to us that would, I believe, accommodate our request under the subsection 2 of this particular motion.
Okay.
So I don't think that that is going to be in controversy. The justification, obviously, is manifold in this particular case. I've been doing this some 30 years. Everybody among us is pretty well respected and pretty learned in jurisprudence, especially in terms of criminal law. And I don't think I've ever seen sort of a more obvious and a more troubling set of circumstances that suggest a conflict of interest or a series of conflicts of interest that I believe, and I think the defense believes, puts Ms. Reed in a very precarious position. It's a conflict of interest and a conflict of interests, multiple interests, that I think are debilitating for the Commonwealth. I think they should have been taken care of at the very beginning of this case, and they weren't. And that's led to a compromised investigation. There is an undeniable and unequivocal conflict that is established through the facts with the lead investigator. We've talked extensively about it in our moving papers, Trooper Proctor. There are obvious suspects that were overlooked during the course of the investigation that relate to and are connected directly to John O'Keefe's killing, his death. What are some of those? We've highlighted several for the court in our moving papers, but I want to bring to the court's attention a couple of things given the Commonwealth's response, which we got this morning, a couple of hours ago. They indicate that we went on this fanciful, is the word the Commonwealth used, a fanciful journey in terms of the facts of the case. Nothing could be further from the truth. We supplied or supported our moving papers on this particular motion alone with some 34, 36 exhibits that are directly out of the Commonwealth discovery that they provided to us, as well as our own investigation. One of the most compelling facts is the timing of when individuals involved in this scenario knew that John O'Keefe had met his demise when he was dead or when he was dying. The allegation suggests that the first time anybody knew about his death was at 6:04 a.m. or so on the 29th, when Karen Reed, my client, along with Jennifer McCabe and one other individual, another female, showed up at the scene and found his body laying prostrate in the front yard of the Albert's house. Except for the fact that Julie Albert indicates in a police report, in an unguarded moment, an unguarded interview with the police, that she actually found out about Mr. O'Keefe's death at 4:55 a.m., more than an hour before his body was ever discovered. How did she find out? According to her, she received a 4:55 phone call from Jennifer McCabe. That means somebody's not telling the truth. That means there's something else going on here. How is it possible that Julie Albert and Jennifer McCabe could have known about John's death before anybody ever arrived at the scene to find the body? Well, there's one way that they could find out, because they knew from other witnesses that were at the Albert house that the body was there. That's the only explanation. Second, and just as troubling, Matthew McCabe, and a lot of these people, Your Honor, I think you'll find, I almost need an org chart to keep the individuals together, but they're all related by blood or by marriage. Most of the people at the Albert house that night. There's a couple of individuals, which we'll talk about in just a second, that were very, very close personal friends, but most of the people are related by blood or by marriage. Matthew McCabe, a brother-in-law to Brian Albert, has indicated in police reports that, amazingly, he looked out a kitchen window out of the Albert's house. And one of the more incriminating points that the Commonwealth relies on to suggest that my client had something to do with the death of John O'Keefe is a V-shaped or an inverted V-shaped set of tire tracks that indicate a three-point turn. It must have been, so they claim, this three-point turn that led to the demise of Mr. O'Keefe. That's when she hit him. She's charged with murder for a three-point turn. What's the problem with that? Mr. McCabe specifically says, I looked out the window and I could see tire tracks that were in the shape consistent with a three-point turn out in the street. Well, he's looking across a yard. You're on the yard, and I'll use a a Massachusetts analogy, that yard is like a hockey rink. It is as flat as you can possibly get. I've been there. I've seen it. There's no undulations. There's no big ditches. There's no big mountains or berms in the yard. It's just flat. If he looked out the window and saw and was able to see something as detailed as tire tracks some 40 yards away in the road, he would be looking directly across the yard where the body would be laying, a 6-foot man in dark clothing, except he never saw a body. How is that possible? How could he see the tire tracks that led to Mr. O'Keefe being killed right there in the yard and not see Mr. O'Keefe? Only one of two things could be true. Either number one, he saw the tire tracks and Karen Reed had already left the location and John O'Keefe was not dead yet and was not in the yard. Or number two, he's lying about having seen the tire tracks in the first place because there were no tire tracks that were suggestive of what he testified or what he stated to the police, and therefore there was no body. Either way, it's exculpatory to my client, the communications that he was having concerning those very specific issues and those very specific facts. And that's why we need, in no small part, to get these communications from that night and the few nights thereafter, the few days thereafter, leading into February 4th, when the investigation continued. Number two, there is video evidence that confirms that there's something that was tampered with, physical evidence during the course of this investigation that was tampered with and just simply doesn't add up. And it was likely placed at the crime scene. As I indicated, the suspects in this case, I think, are all integrally involved with one another. That includes Trooper Proctor. Trooper Proctor is a close family friend of the Alberts, a close family friend of people connected to Brian Albert, Brian Albert's direct family, his brother and sister, our brother and sister-in-law, their children, his nephews. They are all interconnected. We're not just making that up. It's not fanciful. We've provided the Commonwealth and the court with documentary evidence, photographic evidence of them all being involved in, for instance, things as innocuous as, a wedding photo. There's no way to separate Trooper Proctor's conflict with this investigation when he should be investigating everybody involved. If a dead body shows up in the front yard of a party where everybody's drinking, everybody's drunk, and a guy ends up dead in the front yard, one would think that a reasonable investigation would include every single person that was at the party. They're all initial suspects, everyone. Yet amazingly, none of them were. Trooper Proctor even gathered everybody together and interviewed them all at once after Brian Albert had a family and friends meeting in his house about the investigation. One wonders what was discussed during the course of that meeting before Trooper Proctor began his interviews. The taillight. Much has been made by the Commonwealth about shards of taillight that were found at the scene. The Commonwealth didn't spend a whole lot of time on this in their responsive paperwork because I think it's a fact that is very inconvenient, or a series of facts that are very inconvenient for the Commonwealth. First of all, the Commonwealth indicated, and I'm going to go through a little bit of a timeline, but not super detailed because it's detailed pretty clearly in our moving papers. They indicated that Trooper Proctor took possession of that SUV by going to Karen Reed's parents' house, ultimately ending up in a seizure of that vehicle. The Commonwealth indicated in their papers that he didn't arrive at the parents' house until 4:30 p.m. on the 29th. It's not true. His grand jury testimony was that he arrived at 2:30 p.m. He was gone by 4:30 p.m. Why is that important? Because according to his report, even though we know that he testified at the grand jury, he got there at 2:30, we have video evidence of when the car was actually seized. It was seized at 4:12. In his paperwork that was submitted to support his investigation, he indicated that he didn't seize the car until closer to 5:30. It was an hour and 18-minute gap between when he actually had possession of the car back at Canton Police Station And when he said he had possession of that car, why is that important? Because Trooper Proctor was the only person to have possession and access to any shards of taillight that would have existed in this case. Two, not one, but two sets of officers, unconnected to Trooper Proctor, searched that scene where John O'Keefe's body was found immediately after he was removed from the scene to attempt heroic efforts back at Good Samaritan Hospital, and then ultimately was transported to the coroner's office. Two sets of officers. One of them even used a snowblower, which is beyond conception that someone could reasonably think that it was reasonable to go out and use a snowblower to remove snow. How about sifting the snow for evidence if you're looking for small pieces of evidence? But not only did they not find the shards of glass or shards of taillight, the plastic or plasticine that was used in taillights, they didn't even find a shoe that was later discovered. There is no conceivable way that two sets of officers who were out looking specifically for evidence in white snow could have missed bright red shards of glass. But amazingly, after Trooper Proctor had possession of the vehicle, he then calls what's called a CERT team, that special investigations team that comes back out to the crime scene. And he called them and said, I want you to go back out to the crime scene and do another search. Don't go yet, but eventually I'm going to want to have another search done, and I'll let you know when. Keep in the back of your mind this hour and 18-minute gap. It was after that that the CERT team comes back out to the scene, and miraculously, shards of that tail lens, which Trooper Proctor had access to and didn't put in his report, show up at the crime scene. And that's the only physical evidence that connects my client in any way, shape, form, or fashion to that scene or that incident. It certainly makes one wonder what was happening with the Alberts, the McCabe's, Trooper Proctor, that meeting that everybody had, and the conflict of interest that Trooper Proctor very clearly has with the individuals that he should be investigating. You would think that if the Commonwealth's position is correct, the first thing they would want to do is establish, okay, well, she hit him with a truck. She shattered the back tail lens. By the way, a tail lens that you likely couldn't shatter if you had a hammer. But let's say, speaking of fanciful, let's talk about a fanciful argument. Let's say that she was able to put it in reverse and hit a 6-foot-tall man. I'm only 5'10", but I'm a good 3 feet, 2.5 feet taller than the tail lamp of an SUV, of that SUV specifically, which is about 42 inches off the ground. Now you'd have to believe that he was bent over at the waist, he was hitting the back of the head, he'd have to be looking the opposite direction. According to Trooper Proctor, there was glass from a cocktail glass found on the bumper, which means he'd have to have his left hand above the bumper, shatter the glass that he was holding in his left hand, get hit with a taillight in the back of the head, and shatter the taillight. How about blood? How about tissue in those taillight shards? Zero, not one bit. No evidence of blood or tissue or human tissue in any of those lenses or those lens shards that were found. And that's because at 5:07, and the Commonwealth knows this, they're well aware of this fact, at 5:07, a full 5 hours after John O'Keefe was killed, or close to it, left for dead, 5 hours later, in a panic to go find him because he hadn't come home, Karen Reed gets in her SUV, backs out of the garage, and hits another car. With what part of her car? The passenger side taillight. That's how that taillight got shattered. And that's established unequivocally through physical evidence and video evidence. There is also, and I'll make one more point and then sort of wrap up my argument. There's also an enormously troubling set of circumstances surrounding some of the wounds that Mr. O'Keefe suffered on that night. In addition to the head wound, it looked like, as some have said, he had gone 5 rounds with Mike Tyson. He was beaten severely. and the head wound in the back of the head caused a skull fracture or a series of skull fractures. His right eye was cut. The right part of his nose was cut, consistent with punches being thrown, consistent with a fist fight. He also had defensive wounds that the medical examiner for the Commonwealth recognized and noted and brought up herself in her grand jury testimony. Defensive wounds to the back of the hand. How do you get defensive wounds if you were just struck one time with a taillight on the back of a car? You can't. But there were also other wounds, dog bite wounds. I submit to the court, let's put it this way, animal wounds. It looked like he had been mauled by an animal on his right arm, only his right arm. Not his left arm, not his shoulders, not his face, not his legs, not his knees, not his feet, just the right arm. The Alberts owned a full-grown German Shepherd. According to the police reports that we received, even Mr. Albert was somewhat tenuous about having that dog around humans, around people. Why? Because the dog doesn't necessarily get on with people that well. In other words, he's prone to attack. There's very obvious wounds that are inconsistent with this one strike from a car. The Commonwealth's theory is not that he was dragged underneath a car. There was no gravel, dirt, or other debris found in those wounds. Yet he's got these wounds that are consistent with an animal. And the Alberts own a German Shepherd, which they claim, Brian Albert claimed, he let out into the backyard at least once during the course of that night. Probably in another unguarded moment in an interview with the police. One of the things that would be incredibly important for the defense would be to take tissue samples from those wounds and compare them to canine DNA. What do we need for that comparison? We need the dog. Mr. Yannetti, before I was on the case, back in May, as a matter of fact, it was May 6th, 2020, for the first time came to court and gave notice about the defense's concern about those dog bite marks, or what they look like animal bite marks, and mentioned the fact that the Alberts owned a dog. We have now found out that in that same month, May of 2022, the dog is now miraculously missing. After being in the Albert family for not months, but years, that dog is now gone. Our investigators have interviewed animal control experts and those custodians, and those custodians have indicated that according to their documentation, that dog was turned into animal control. It was quarantined for the appropriate amount of time pursuant to Massachusetts law, and then ultimately it was rehomed, as they say. In other words, the dog's gone. Seems like an awfully convenient fact, again, suggesting that something was going on, decisions were being made, communications were being had by and among, or between and among, the very individuals that we're asking for communications for. There's no way that all of this could have been pulled off without some sort of agreement, this sort of cover-up of actual facts and actual evidence, this sort of inconsistency and convenient inconsistencies with physical evidence and testimonial evidence can't be pulled off without an agreement and consent of several people. And what do people need for a cover-up? They need communication. And how do people communicate these days? With a cell phone. I would bet that the court has a cell phone within arm's reach. I'll bet you everybody in this room has a cell phone within arm's or pocket's reach. That's how modern society communicates with each other. We're not asking for extraordinary information. We believe that there are certain exigencies and urgencies involved. We want these communications for a very limited, a very bracketed, and a very specific time frame. We're not looking to invade anybody's privacy, but Ms. Reed has a right to investigate this case the way that the Commonwealth should have investigated the case from the beginning. I was actually a bit surprised. We spoke with Mr. Lally this morning, by the way. First time I've spoken to him off the record. He's an incredible gentleman, an incredible professional. He was extraordinarily gracious to us during the course of the conversation. But my question is, during the course of the investigation, why wasn't he asking for this? This would be an obvious set of facts that any police officer who wasn't biased and wasn't compromised would have asked for. You've got a party and you've got a dead person who was at the party. Find out who's communicating about that and why. But of course, that never happened. And the Commonwealth is resisting the very evidence they should be seeking. Why? I'm sure somewhere along the line, all of the DAs involved swore an oath to seek the truth. And that's all we're asking for, is for the court to allow us to properly defend Ms. Reed by seeking the truth. And the truth will be whatever it is. But I suspect, as a matter of fact, I know, based on the evidence that we have so far, that there's going to be information and communications between and among these individuals that will lead to exculpate Ms. Reed. She didn't do this. She's entitled to exculpatory information that proves that and establishes that. And I'll submit unless the court has any other questions.
All right. Thank you very much. Mr. Lally?
Thank you, Your Honor. Your Honor, just to clarify, because I know obviously Your Honor wasn't present on the last time we were before the court in reference to this. Today is essentially just the 17A2 portion of the first portion of the Rule 17. So, obviously, given the short notice, I was able to provide, as counsel had requested, and Judge Krupp had ordered notice to each of the third party, I guess we'll call them tangible object holders, the notice to reserve, but I didn't provide them with notice of today's hearing. So just with that caveat, I'll proceed. Your Honor, the Commonwealth requests that the defendant's motion be denied. The defendant here submits no supporting affidavit as is required. And yes, I did posit a fanciful facts section contained within the memorandum, but it's a fact section that is entirely bereft of any evidentiary support for the conspiracy that purportedly exists and forms the basis for these requests for the subject cell phones at issue here. As the court is well aware, Rule 17 is not a discovery tool. It is not a possibly or potentially there could be evidence of something going on. If I could just address a couple of the facts or the evidence as outlined by counsel as far as the justification for this being manifold. The conflict of interest that the Commonwealth has fully vetted and does not believe that there is any conflict of interest here between Trooper Proctor and the Albert family in this investigation. Any relationship is ancillary, tangential at best. These are not people that socialize together. These are not people that know each other. These are not people that Trooper Proctor has been over to their home prior to going to their home to interview them in relation to this case. The phone call that counsel references from Julie Albert, and this is part of the issue that I take with some of these submissions, that were including the grand jury transcripts, in which it's essentially parceled out 2 pages here, 3 pages here, 5 pages there, completely divorced from their context. This, Your Honor, was an extensive grand jury investigation spanning several months over 14 different dates. There were 42 different witnesses who testified before this grand jury. So there were more than that with some repeat witnesses, some of the investigating troopers being among them. But there were 42 separate witnesses that testified, over 1,445 pages of grand jury transcripts. So to take 2-3 pages here or 2-3 pages there is disingenuous at best, I would submit. But this phone call that Julie Albert is alleged to have received from Ms. McCabe indicating at 4:53 that Mr. O'Keefe was dead was a phone call that Ms. Albert testified she missed. She was asleep. So that was the intention of the phone call. May have been to inform her of something, but it's not a phone call that she received. As far as the 3-point turn is concerned, the only person, and this is a bit troubling as the case has gone on, the only person who has ever said that there was a 3-point turn by Miss Reed in front of the house was Miss Reed to the troopers later on that day. None of the witnesses ever said they saw a 3-point turn. None of the witnesses ever said there was any evidence of a 3-point turn. That's simply one of the varying accounts that Miss Reed provided to independent witnesses and the troopers over the course of this investigation. As far as the video confirming that evidence was tampered with, is apparently a ring video from the defendant's parents' house in Dayton. I've never seen the video. I've never seen anything beyond what's contained within this submission. It does have a date and time stamp of 4:12 p.m., but from the photograph, as the court can see, the subject vehicle is not on the record at that point. It's not on the tow truck. I have no idea whether or not that time and date stamp is accurate, whether it was an hour off because of daylight savings time. If it would be, that would make it 5:12 p.m. and then 5:30 on the record would conform with that. There's simply, throughout the course of this recitation, as far as the taillight is concerned, being damaged in the driveway of Mr. O'Keefe's home, there is a Ring video application from his driveway, which shows Miss Reed backing out of the driveway at 5:08 a.m. We obviously have her cell phone's whereabouts and movements, so it takes about 21 minutes or so before she shows up at Miss McCabe's home, which is probably about a 2-minute drive from there. But from that video, the vehicle backs up with more than sufficient room to cut the wheel and make the maneuver without making any contact with Mr. O'Keefe's vehicle, which is parked way in the back to the far right side of the driveway. It appears that the vehicles come close to each other. However, there is no evidence of any shards of glass of a taillight found in the driveway. There's none that can be seen in the video, and there were none that were recovered when the troopers went there. The troopers also photographed both the victim's vehicle, a complete 360, probably 20, 30 photographs of the vehicle. There's absolutely no damage to Mr. O'Keefe's vehicle. So if Miss Reed's vehicle, that's where the taillight was broken and hit it with sufficient force to break her taillight, there's absolutely no damage to that. There are also the glass shards, which Mr. O'Keefe was observed from the surveillance video from the bar leaving the waterfall with a cocktail glass in his hand. And there are glass shards and pieces of a cocktail glass that are found. As far as the snowblower, there's no snowblower employed here. The Canton police officers grabbed a leaf blower from one of their houses to see if they could sift off part of the snow because they're conducting this initial search while the blizzard is still ongoing, and a blizzard that left approximately 2 feet of snow in that location. So not only would these shards of glass have to have been planted, they would have to have been planted along with Mr. O'Keefe's other shoe that is observed missing by all of the paramedics who arrive on scene, is not with his person when he's taken to the Good Samaritan Medical Center. So they would have had to have packed that under 2 feet of snow in order to put it exactly where the shoe and the shards of glass were found together several hours later by the CERT team. The wounds, just sort of bald assertions by counsel that it must have been from a fight, that there are defensive wounds. There is no indication that there are any defensive wounds. The medical examiner, Dr. Irene Scortibello, testified before the grand jury. Counsel has the entire report. Counsel has her testimony. She was specifically asked if any of these injuries were consistent with a physical altercation, and she said no. The injuries to his face, as she details throughout her grand jury testimony, were a result of the defendant falling backwards, striking his head. There is a gash in the right back of his head, which essentially matches up with the sort of radiating skull fractures that he has from the frontal, occipital, and parietal areas of his skull, which then caused internal bleeding on the brain, which then caused the eyes to swell and caused the blood to come from his nose and his mouth. It's extensive, over 50 pages or so of grand jury testimony from that medical examiner in relation to that. Nowhere does she characterize anything as bite wounds, let alone animal bite wounds, that he was mauled by any sort of animal on his right arm, nor is there any indication of any defensive wounds whatsoever. So essentially, Your Honor, Commonwealth would submit is submitted here is yes, I would agree with counsel that if the court were to entirely adopt the set of facts as proposed within the memorandum, again, not in an affidavit, but in the memorandum attached to the defendant's motion, then certainly there would be some grave concern for some sort of large overarching cabal or conspiracy between some 10 civilians, the entirety of the Norfolk County CPAC unit of the state police, Canton police officers, 2 of those civilians, one being a Boston police officer, the other being a federal agent. I suppose the medical examiner would have to be in on that. I'm not sure who else would probably fit within that conspiracy, but I think that there would have to be a number of other parties who were involved in this frame job when it comes to Ms. Reed. With respect to the Rule 17 motion, Your Honor, there needs to be a submission by the defendant
First of all, the time frame the Commonwealth would submit is overbroad. Secondly, the content sought is not limited to merely communications between the alleged members of the conspiracy. It's any and all communications contained in their phone. All of that being overbroad, and all of that as far as being completely bereft of any sort of evidentiary support other than mere circumspection or speculation, which the case law, as in Bourgeois, as in plenty of other cases in support of that, simply don't allow Rule 17 to be used as this sort of discovery type tool. Lastly, it troubles, it is a bit troubling that if counsel is to come into court and file a motion for 7 individuals to turn over their phones to him or to his directed expert based on this scant factual underpinning. Obviously, as the court is well aware, if the Commonwealth were to seek a search warrant, obviously we'd be relegated to the standard of probable cause. This doesn't even come close to that as far as an evidentiary support for what's being requested here. The last thing I'll say is in reference to Ms. McCabe's phone. We did speak about that. So there was a full extraction done of Ms. McCabe's phone for ease of presentation to the grand jury, frankly for myself and for them as well. What I did was I marked the full extraction as an exhibit for the grand jury. What I also did was I had a separate extraction done between Ms. McCabe and the defendant, Ms. McCabe and the victim, and Ms. McCabe and Ms. Roberts, who was the other female party that discovered Mr. O'Keefe's body, from that specific time period. And then that extraction was also marked as an exhibit for the grand jury. Counsel has both of those, or should have both of those. They were provided on the arraignment date. So we spoke a little earlier today. If they can't locate it, that's fine. I can make another copy. That's certainly not an issue, but it's asking for Ms. McCabe's phone when they already have it is a little bit troubling to me as well. But having said all that, Your Honor, what I would submit in relation to the Rule 17 is the standard has not been met here, not even close. And for that, I would ask that the motion be denied.
Okay. All right. Did you want to respond, Mr. Jackson? I see you writing away over there.
Very, very briefly.
Okay.
First of all, there is a declaration that supports the motion. I think the court can see it. It's at the very back of the motion. It was submitted. It's
a one-page affidavit?
That's correct. That's correct. And it was in support of and adopting the facts that were basically laid out in the motion. So there is a supporting declaration. If it's wanting, we can certainly provide the court with something more robust, but it is a supporting declaration that does meet the criteria that's necessary. With regard to some of the facts that were just discussed, the phone call at 4:55 may have been a message that was left, and Miss Julie McCabe didn't answer that call. We don't dispute that. But what she said to the police was, it was that call that informed me of John's death at 4:55 a.m. So whether she picked up the call immediately and then listened to the voicemail or listened to the voicemail 5 minutes later, it is uncontroverted that that was her statement. Number two, with regard to the video, the Commonwealth just indicated, well, there's no evidence that the timestamp on the video is right. Well, then make it right. If that's what the Commonwealth's position is, they've got all the governmental resources, go calibrate it. It is a Ring video. Ring videos, I think it's pretty common knowledge. I've got one. I bet a lot of people in this courtroom have one. They're Wi-Fi. They're connected to the Wi-Fi. Wi-Fis are connected to the satellites. Satellite is calibrated time all the time. So Ring videos are calibrated time all the time. It was 4:12, and by the way, one quick glance at the video, watching it all the way through, it actually shows the car being driven onto the truck. So it physically shows the car being removed from the scene. Number three, the 5:07 video, 5 hours later, showing my client backing frantically out of her garage to go look for John O'Keefe, actually does show the other car wobble. It shows contact. You can see the other car move. That, coupled with the fact that when she then drives, she puts the car back into drive and she moves forward, there's a flash of white light that comes across from the tail lamp lens. That tail lamp lens, and I think the court has pictures of it now, is all red. It's completely enclosed. It's a wraparound enclosed red lens. The only way a white bulb would be seen is if there was a crack, a crevice in that taillight lens. So it's unequivocal that that lens it made contact with the Chevrolet moves, and the lens is thereafter cracked, and you can actually see the crack on the video. With regard to evidence that was, quote unquote, as the Commonwealth indicates, planted, and he wants to make this some big conspiracy theory that's completely unbelievable. Therefore, Your Honor, you can't believe this. The ME has to be involved and other people have to be. We never said that the medical examiner was involved, and I don't know how many people are involved. I know that there were individuals at that party, the people that we listed, who know more than what they're telling us. We know that through the circumstantial evidence and direct evidence of other evidence that has been provided us to date. And what do we know about the evidence concerning the animal wounds? The Commonwealth says, well, there's no evidence that it's a wound from an animal. Again, why didn't you check? Why didn't you take tissue samples and then pull a hair off of that dog? It's relatively easy to do. You have a crime lab, for goodness sake. Just take the tissue samples. Now the dog's gone. Isn't that convenient? That puts us in an incredibly difficult position. Why does that matter? Because the only evidence we have about where that dog was that night comes from Brian Albert. Brian Albert said to the investigators, at least one investigator, I let the dog out in the backyard. The only evidence that we know about where that full-grown German Shepherd was is in the backyard. We have Matt McCabe looking out over basically a hockey rink of a yard, not seeing a body. We have wounds. If the dog was in the backyard, and we know the wounds are animal wounds, and those wounds turn out to be dog wounds, then that puts Mr. O'Keefe's arm in the backyard, which puts him in the backyard. If there was no shoe found at the scene, was the house ever searched? It was not. Was the backyard ever searched? It was not. How is it conceivably possible that Trooper Proctor didn't search the entire house top to bottom for evidence of some sort of nefarious conduct leading to John O'Keefe's death? He's facing a situation where a man looks like he's been beaten to death, and yet he doesn't search the house and he doesn't search the backyard. And miraculously, the next day, after two sets of officers, and I misspoke, and the Commonwealth's right. It wasn't a snow blower. I was thinking of snow. It was a leaf blower, a gas-powered leaf blower, much more meticulous than a snow blower. According to the Commonwealth, the shoe wasn't found until after two sets of officers had already searched the entire location, the whole location. How is that possible? If the backyard wasn't searched, could it have been in the backyard? Could the shoe have come off when someone was transporting the body from the backyard to the front yard to cover someone's tracks? It's perfectly reasonable. And if that happened during a party with a bunch of people at it, one would suspect, one would actually know that others would know about it. We have evidence that at least some witnesses have been told, don't talk. This involves a bunch of cops families. Don't talk. We're not asking for anything extraordinary, Your Honor. We're asking to be able to find the truth. The Commonwealth should not be afraid of that. We are working within a bracketed parameter of only 7 days. We're willing and able to comply with any restrictive court order concerning the non-dissemination of those data that we get outside of the defense of this case. We will happily comply with those restrictive orders. But to deny us the ability to actually investigate this case is to deny Ms. Reed her due process rights. And I'll submit. Thank you.
All right. Thank you very much. Then, Mr. Lally, you explained this is the only motion we're going forward on today. Did the Commonwealth need time? I know you were on trial. Do you need time to respond to the other motions that are still outstanding?
Whatever the court's pleasure. I've reviewed them. This is the only one I filed a written submission on, but
Well, it's up to you. Are you looking to, we could go forward, or if you're looking for time?
I'm fine, Your Honor. We can.
whatever. if
All
the
right, so
court-
what
court has time.
exactly is left?
I believe there is a motion for discovery regarding the circumstances of Trooper Proctor's assignment to the investigation of this matter.
Okay, what, is the Commonwealth opposed to that?
Well, Your Honor, I'm opposed, number one, as to the form. These are really more civil interrogatories as they seem to me. I've spoken to counsel as far as any sort of policies or protocols related to conflict of interest, related to assignment. I've explained to counsel sort of the duty schedule of our CPAC unit and how one would be essentially on call, and that's how they're assigned. So if there's a duty roster, I'm more than happy to provide that. But I would object to going through question by question each of the 16 different questions relating to a clear conflict, which I've already stated our office does not feel there is any conflict, let alone a clear conflict. But as far as the written documentation, in regard to the subjects that are covered within the motion, the Commonwealth has no issue with those.
All right. Mr. Yannetti, it seems to make sense that you start with that and get that and see if you need anything more.
Well, I think on the surface, it is an appealing argument, Your Honor, but you know, as somebody who worked for almost a decade with a CPAC unit in another county, I know that I'm going to get literally nothing from that production if that is what the court orders. There will be nothing in writing regarding the assignment of troopers within a CPAC unit attached to a district attorney's office.
Okay. You know what I'm going to do, actually? I'm going to put this back. Jimmy, we've got a lot of people waiting. We can come back and do the rest of your motions after I get through the list.
That's fine. Thank you, Your Honor.
Second call.
Thank you, Your Honor.
Can I have Mr. Abreu and Mr. Gonzalez brought in? Numbers 13 and 14, Jonathan Abreu and Savon Gonzalez. Mr. Sheketoff, Mr. Reddington, and Mr. Martinelli.
I still have her record. I need that record still. But I don't think I have any other records that I'm not keeping. Thank you. You can have a seat, Ms. Reed. All right, so I appreciate everyone waiting. So this is the last case, Jimmy?
Yes.
Okay,
Have I missed anyone in here?
okay.
Or a case? No, that's the last one.
All right, so I will hear you. I think I interrupted you, Mr. Yannetti, on the discovery regarding the circumstances of the trooper being assigned the case.
Yes, Your Honor, I appreciate the court's suggestion about getting a preliminary response from the district attorney's office regarding any policies or anything in writing regarding Trooper Proctor's assignment to this case. I am very pessimistic that that will yield anything that is of any use to anyone. However, I will say that it seems fairly clear that we will need another date at a minimum with regard to the Rule 17 motion that was heard earlier. If the court would prefer to order the Commonwealth to provide what it has indicated that it would provide, and then we can be heard on the specific 16 requests that we make on the next date, I would...
Well, it made sense to me, but I'm not going to tell you how to run your case. So if you'd prefer to go forward on the motion, we can do that, however you want to go about it.
Okay, well, the bottom line, Judge, is we look at this as crucial evidence for the defense. Everything flows from this motion. This is an extraordinary situation. Mr. Jackson has touched upon a lot of these issues, but you have three families that are intertwined in multiple different directions and in multiple ways. We have attached as exhibits to our motions some social media photos between the families, but we have...
But not attached to this motion.
Well, but I do reference the statement of facts and exhibits in the grounds for this motion. Rather than recopy everything for this motion, I referenced them.
All right, so where would I have it? Do you want me to look at what you filed for the Rule 17 motion?
Either the Rule 17 or the geofence, both of the exhibit packages have these social media
Are they the
Photos.
same?
Yes, in those motions they are. I will tell the court that we have additional photos of, Trooper Proctor's sister, commentary by Trooper Proctor's mom on the Albert family and Colin Albert and Chris Albert and Julie Daniels, who's Julie Albert's sister. We have multiple photos of them socializing in addition to the wedding photos that were previously submitted. Quite frankly, I couldn't hear if Mr. Lally had said that they don't socialize or if socializing is not that big a deal. But in either case, we would assert this is a big deal. To the extent that, as Mr. Jackson had said, that there is the body of a dead police officer on the property, found on the property of a home. The people within that home should have been questioned in a certain way, and they weren't. And our assertion is they weren't because they were either police officers or they were related to police officers. And where the rubber meets the road, this is not just a police officer who showed up at the home of another police officer. This is a state trooper who showed up at the home of a friend of his. And the big question is not just how did he get assigned to this case, but to whom did he reveal his extensive social contacts and friendships with the people within that home? Did his superiors know that? Did the district attorney's office know that? Mr. Lally claims that his office has done this extensive investigation to determine that there's no conflict of interest. I don't know how anybody could look at these photos and see this commentary on social media and the intertwining of these three families and come to the conclusion that this was on the up and up, that there was no conflict of interest whatsoever. These questions are very straightforward. They are in the custody, care, and control of the Commonwealth. They are not anything that we can determine through our investigation because we believe there's nothing in writing and we don't have the right to depose witnesses in a criminal case. So these are very basic facts that can be ascertained with a very cursory examination or investigation by the district attorney's office. A few phone calls to the necessary people will accomplish that. This, I believe, will form the basis or one of the bases for a potential motion to dismiss for misconduct by the Commonwealth.
All right. Mr. Lally, when you were talking earlier, I didn't take notes as to exactly what you agreed that you would hand over. So why don't you tell me again? And if it helps you to go through 1 through 16, you can do it that way. But what was it that you said specifically you would hand over?
Well, when there's reference to written policies or procedures of the state police pertaining to case assignments for investigation of suspicious deaths, I'm looking specifically at number 7. And again, it's Commonwealth's position that this is not a discovery motion. These are interrogatories. I mean, that's what they are. They're all phrased in question form and asking, to questions be posed to certain people. But as far as any documentation related to assignment of matters within the CPAC unit, as far as any written documentation, whether that be by policy or written protocols or procedures of the state police related to assignment or related to any potential conflict of interest. I'm certainly happy to inquire in regard to those and provide whatever written policies and procedures there are. I'm also aware that there is a duty roster basically detailing who is assigned and who is on duty at a specific date and time, and I'm certainly happy to provide that for the entirety of the month of January of 2022.
Okay. All right. So I'll take this under advisement along with that Rule 17 motion that we heard earlier. All right. What else do we have to?
Your Honor, I think there are 3 motions left for the court today. One is our amended motion to compel modification of Google preservation requests and for production of geofence data.
Had you talked about this previously?
Yes.
All right, and do you still, I know Mr. Lally was on trial all last week and then some the week before. Mr. Lally, I don't have a written response from you on this. Again, this is another one where the grand jury minutes have to be
That's fine, Judge.
impounded.
That's fine.
Mr. Lally, are you objecting to this? Do you want to put something in writing? I'm happy to hear you today. How do you want to go about this?
No, Your Honor, we've spoken with regard to, just with regard to the, if you direct the court's attention to page 21 of counsel's motion, when it states requested relief.
Yes.
So number one with regard to that is that the court order modification of the preservation request to include all smartphones and include applications downloaded from the Apple App Store. The Commonwealth would submit that it already has been modified and that's been provided. Two, that the court order production of the automated acknowledgement and receipt of the modified preservation request from Google, and B, confirmation of intent to comply with the request from Google. I believe that those have, and when I was speaking with counsel today, what I indicated was I was a little hung up on trial, but I've since talked to the troopers, and essentially I think it might be a little confusion on my end as this has been an ongoing issue since like May as far as what I provided and what hasn't been. So
The arraignment wasn't until June, right? So
no, so this goes back all the way to pre-indictment when the case was pending in the Stoughton District Court. So essentially what I've asked the troopers to do is to just literally give me everything that they have as far as the geofence is concerned, which I should have in the next couple of days, and I'll provide that to counsel. And if there's any further requests, I think we can deal with that on the next date. The last thing, as far as the anonymized list, I have no issue with that. So I've agreed to provide that, should there be one as well.
On that last point, Judge, just so the court's clear, that anonymized list is the crucial evidence in this case. Our position is that for the reasons we've stated and the showing that we've made, Trooper Proctor or the Massachusetts State Police, and for that matter, the Canton Police, should not have custody of that anonymized list. We want that anonymized list, which would be produced in response to the search warrant that was issued. We want that sent directly from Google to the court. We do not want this in the hands of...
do they already have it?
I believe that they already have the response, and that's how the order was drafted as far as the search warrant was to, we don't do a search warrant to return something to the court of that nature. That's not how it's done.
Ultimately, Your Honor, it's the property of the court, not the Commonwealth, given that it was produced in relation to a search warrant. But if it's already been sent to law enforcement, we would ask that forthwith it be transferred to the court. And then if this court sees fit to issue any protective orders regarding counsel viewing that, we would abide by that. Given that the list would be anonymous, I don't know that that's even necessary because it would not identify anybody in particular. But our concern was that the search warrant was written in such a way that the state police, or Trooper Proctor specifically, would excise from that anonymous list anybody that he deemed to be not in the area for a sufficient period of time to be relevant to the case. And by definition, there is nobody that would fit that category in our view, because their theory, again, is that Officer O'Keefe was killed somewhere around 12:30 a.m. Anybody that drove by that residence or entered that neighborhood that is blocked off by the search warrant is relevant, because they either saw a body in the yard or they didn't, and in either circumstance, they're relevant to this case.
Mr. Lally, do you want to respond?
I mean, other than...
You don't have to. Have you seen this?
Yes.
All right, so you're going to provide what you have. There's no need for a protective order, or is there? I haven't seen the search warrant. I haven't seen the affidavit.
Whereas the
support of the
list
search
would
warrant.
be at this stage, so this would be stage one of this particular proceeding. So whereas any list would just simply be a list of phone numbers, I don't see any
Okay, so I didn't know where you were at. That's where you're at. You're at the
We're just
first
at
stage
stage
with just those phone numbers?
Correct.
All right, there's no need for me to take that, Mr. Yannetti. There's no need for me to take that list of phone numbers, to take custody of that list of phone numbers. We haven't done the second part of that yet.
Okay, so the court's ruling is that that list of phone numbers will be provided directly to the defense from the prosecution.
That's what Mr. Lally said.
Okay,
Yes, sir.
all
I
right,
have no reason to doubt what he said.
okay. And then the last motion that I have before my colleague Ms. Little argues the remaining one is defendant's motion to renew motions previously filed in Stoughton District Court prior to indictment.
Yeah, I think that's somewhat problematic. If you're trying to build a record here, what we've got are different docket numbers, Stoughton District Court. Can you go back through your list and see which ones you want to file here? If there's a question that you want to put on the record, everything that's been preserved, I'm sure you and Mr. Lally can put that on the record in some form. I thought that might be your intent, but what is your intent in simply filing motions that were filed in a different court rather than just filing what you think is appropriate in this court?
Well, I wanted to flag for the court that these motions would not be brand new, that these motions were ordered by Judge O'Malley in the Stoughton District Court.
You can do that by way of affidavit, right?
All right, fair enough, Judge. What I did do is...
I just think it's a nightmare, Mr. Clerk. Is it?
Yeah, yes.
Oh, okay. Yeah, no, what I had done is I had attached all of those motions as part of this motion to renew, so they're all in one place within the motion. They're all part of that one motion. No new docket numbers need to be created because they're part of the motion where the face has our docket number. But however the court wants to proceed is fine. I want to make sure we're protected.
Yeah, you have to, in order to protect you, you have to file separate motions.
That's fine, Judge. And the remaining motion would be a motion to compel discovery, and Ms. Little is prepared to address that.
Okay,
Good afternoon, Your Honor. I'll be relatively brief because I know
that's okay. Take your time.
Okay. Our motion to compel discovery is largely focused on three sort of major issues. The recovery and handling of evidence. We're very interested in obviously finding out when and by whom that evidence was recovered. We've requested chain of custody documentation, 911 call logs, and dispatch records. And all of that is going to help us sort of sort out who responded to the scene and collected what evidence in this case. The second sort of bucket, so to speak, of information that we're requesting are communications between and among the Massachusetts State Police, the Canton Police Department, and the critical witnesses in this case. And that, as we've sort of discussed all day today, is Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, Brian Higgins, Colin Albert, and Julie Albert. The third sort of category of information that we're requesting is the identification of an unnamed female witness who was at the party that night, on the night in question, and was actually driven home in the early morning of January 29th by Jennifer McCabe at 1:30 a.m., meaning they both would have left the residence, 34 Fairview Road, after Ms. Reed is alleged to have already struck Mr. O'Keefe with her vehicle. We have not received any information about who that person is. Several people have mentioned that she was present.
Was she called the girlfriend of somebody that was driven home, from what I read here?
So
Do you have a name right now, Mr. Lally?
I don't, but what I have upon receipt of this motion and some of the others, so when Ms. Nagel was never actually interviewed either. So what I asked the troopers to do upon serving notice of the preservation, they have now set up an interview with Ms. Nagel. They're going to inquire of Ms. Nagel who that other party is, and they're going to interview her,
Okay,
whoever that be. But at this moment, I don't know.
okay.
I have conferred with Mr. Lally, and he has been gracious and offered to get us the information that we're missing. What I would propose for the court is that we set up a time to meet with him sometime between now and the next court appearance to make sure that we get all of the information that we've requested. And unless the court has any specific question or Mr. Lally has any objections, I will leave it at that.
All right, thank you. All right, Mr. Lally, what do you say? Is there an objection to any of this?
Your Honor, a lot of this has already been provided, but I'll certainly spoke to counsel earlier today as far as making additional disk copies of photographs, things of that nature. I'll inquire as to the 911 calls and dispatch logs, things of that nature. The only thing that I would really have any issue with or objection to would be the communications. So number 6, number 7, number 8, number 9 are all essentially asking for the same things from different people. Number 10 as well. And I'm not sure that I fully understand number 14 as far as written confirmation. The digital timestamps are, if you're asking for the metadata, I think that would cover that.
The metadata would cover that with respect.
So you want to provide the metadata?
That's, again, I believe that they should already have the metadata, but I'll certainly make further copies of those photographs as far as in their digital format and provide that to counsel.
All right, so this is one that it does make sense to me. I don't care if you meet in person or if you formally meet, but narrow it down for next time, anything that you think that you're entitled to that has not been provided.
Thank you, Your Honor.
Absolutely, Your Honor.
All right, is that it for today?
Just one other thing, Judge, which is I wanted to clarify for the court, or have the court clarify for us. I believe it's not going to be contested, but there is a stay-away order in effect and a no contact order in effect for Ms. Reed. I want to make it clear on the record that a defense investigator and/or attorney is not prohibited from contacting any witness who may fall within the purview.
You understand that, Mr. Lally, right?
Yes, Your Honor.
Yeah.
Thank you.
Okay, is that it?
That's it.
Nothing further for the Commonwealth, no.
Do we have a next date, Mr. Clerk?
We do not.
Your Honor, the parties have conferred, and we're asking if the court would allow for 2 p.m. on November 21.
Is that the Monday before Thanksgiving?
It's
It
the Monday
is.
of Thanksgiving week.
It's probably not a good day.
The only reason I don't like that day is because I put a jury waive case on that day and I promised them they'd have all day.
Oh, I see. I see.
If I may, Your Honor, just for purposes of housekeeping, Ms. Little and I are going to be in trial. We say in trial, on trial.
On trial.
On trial in Massachusetts.
On October 10th in an extremely broad case. It's probably going to last 3 months. I'm going to ask the court in the Weinstein matter to give me a Monday because I can make it out here on a weekend. I can appear on a Monday.
You can appear via Zoom, especially if it's entirely up to you, but we can accommodate you on Zoom.
I didn't realize that. That may give us some reprieve. It'll certainly save me a bunch of time.
Any objection, Mr. Lally?
No, Your Honor.
Not for any evidentiary motions, but for arguments like today. It doesn't make any sense to me that you fly all the way out here for this.
Understood. That's very accommodating. I appreciate it. Then that relieves me of a significant.
So you're behind us by 3 hours, right? But we do afternoons.
That's right.
So
So it'd be 11 a.m. for me.
I'm going to, based on that, Your Honor, with your permission, I think I'm going to amend my answer to that the 21st is fine.
Okay.
I don't think that jury waive case is going to take all day. It's basically an agreed upon set of facts. So
Okay.
I think 11:21 actually
Thank you,
will
Jim.
work.
Thank you.
okay.
2 p.m. though, 2 p.m.
And
Excellent.
I'm sorry, just,
And we are going to do that by Zoom?
Well,
You could do.
No,
It's an option.
counsel should be here. The counsel from California certainly doesn't need to be here, but it would make sense if you're right down the street for you to be
Agreed.
here.
Thank you.
and I'm sorry, just for what event, Your Honor?
Right. What are we doing? You said you all conferred. I assumed you meant for a specific event. What event?
I believe it would be a continuation of this motion hearing to the extent that there's anything left to decide.
Okay.
Further hearing on discovery motions is fine, and then obviously I
Okay.
can direct people depending on the court's ruling on the Rule 17.
Okay. All right. See you then.
Discovery compliance, does that sound?
Further discovery motions, Jim.
Thank
And
you, Ron.
Mr. Lally, you'll make every effort to get everything that you expect to give counsel prior to that date and work on narrowing what might still be outstanding.
Absolutely.
Thank you.
All right. Thank you.
11:21 at 2 p.m. Discovery motions. Thank you.
All right. These are all under advisement. Jimmy?
thank you, Your Honor.
Sorry?